Hey, good afternoon, everybody. This is John, and we are officially in the last week. It's hard to believe that seems like this class flew by with all the disruption and chaos all around us. And I know I've heard from several of you who've certainly experienced that. I'm sure all of you have, some more than others, certainly, particularly with respect to working extra hours and working from home and whatever you may be doing. Very impressed with just the ability of people in this class to juggle these different responsibilities and be able to get through this class. Very difficult. So kudos to each of you. I don't have a lot. Obviously, we don't have a discussion question this week, but I do like to take this last week to go over some what I feel are the most important takeaways from this class. And of course, as I mentioned from the very beginning, my main objective in this class is to help you get some value out of it, and whatever that value is to you, um, it could be very different. For me, the value of this class is learning how to think critically about healthcare legal and ethical issues. Meaning, for example, the HIPAA privacy discussion question that we had, where intuitively one may look at that question and think, oh yeah, well, someone looked at uh, protected health information, somebody disclosed it to someone else, definitely that's a breach. And really, when you think about these issues critically, the issue is a little bit deeper than that, and requires a little bit more analysis. Requires application of a rule. Requires understanding what that rule is, and then understanding what the facts are and applying those facts to that rule. So that is, to me, what I hope you get out of this class. So, just for me, I just want to highlight some what I believe are the main takeaways from this class. Sometimes, remember, there's a marked distinction between ethics and legal liability in healthcare. I think it's really important to remember that you can act perfectly, you can be very ethical, you can act in a very ethical manner, comply with your whatever the requirements are for your professional code of conduct, and still, despite all that, still have some exposure to legal liability, particularly with respect to malpractice, because the ethics, while sometimes they overlap with legal issues, not always. And so the key is to look at those elements of a legal malpractice case and understand whether or not you have facts to uh, support those elements, regardless of what the ethical issue is. So there's a distinction between ethics issues and legal issues. Although sometimes they overlap, they don't always. You can certainly act ethically and still have exposure to some level of legal liability. Remember, malpractice and the whole concept of legal analysis. Very important part of this class. Remember the four elements of malpractice, medical malpractice, that have to be present in order for there to be liability. The one is duty. Duty occurs when upon the formation of the physician-patient relationship. The second element is a deviation, a breach of that duty or a deviation from the standard of care. Remember what that rule is with respect to standard of care. What is the standard of care? How is that met? Remember that the standard of care is sometimes very litigated in a medical malpractice case and argued by both sides. You may have an argument that we should look at this broad national standard of care for this particular issue, whereas someone from a more rural, let's say the incident occurred in western Kansas or some very rural part of the country, and they may argue, no, we don't have access to all the same specialists and providers and information that you may have in some urban facility. Therefore, the standard of care is lower. That is the argument that may go back and forth depending on the context and the facts. The third is causation. And remember, there are two types of causation, but causation is very important. Did the incident actually cause the harm to the patient? There's direct causation, there's proximate causation, and those are very important to understand. And then finally, there has to be damages or harm to the patient. If there's no damages, if there's nothing, there's no harm, regardless of how egregious the facts are, there's no medical liability, there's no medical negligence. So it's an important element to establish in a medical malpractice case. It's very important, and when I gave feedback on the assignments throughout the class, I really stressed and emphasized the importance of analyzing each one of these elements. It's very important for one reason. If even one element does not exist, or the absence of even one element, that means that there is no medical negligence. There could be negligence. Someone made a mistake. Someone made some inadvertent mistake that caused some harm. That could be. Just because someone made a mistake doesn't mean there's medical negligence. Doesn't mean there's liability for medical malpractice. That's very important to understand. You may look at some facts and say, oh, this doctor or this practitioner did a terrible job and made all kinds of mistakes, therefore there's negligence. That's not true. You have to establish every one of those four elements in order for there to be, from a legal perspective, medical negligence. So that's sort of taking off your kind of everyday way we look at the world and everything. Take that hat off and put on your legal hat on, and understand that these elements have to be established. You have to think about these from a legal perspective. Think about them critically. Go through that IRAC method of analysis: issue, rule, application of facts, and conclusion. To me, this class is not about right answers. There are many classes that you have taken and will take that are about getting right answers. This class is not like that. This class is not about getting right answers. It's about how to think about the right answer. So how do we think critically? How do we establish an argument or think about things through this legal lens? That I know the legal lens can be annoying and irritating, but that's kind of what the legal lens is. It is annoying and irritating, but you have to think about these things critically and break them down by their individual elemental components. So like I said, the legal analysis for me is huge. Define the terms, look at the relevant facts, look at the rule, apply the facts to the rule and the defined terms. Like the same example in terms of what is a breach. When we think about breach, we just think of something inappropriate or something went wrong, but that's not what breach is. If you look at the HIPAA, at least in the privacy context, if you look at the HIPAA regulatory definition of breach, it consists of an entire analysis. There are factors to consider. There are exceptions to what may be considered a breach, and all those have to be considered. Finally, we talked about the business and economics of healthcare, the private group health plans, managed care, Medicare, Medicaid, Medicare Advantage. And we talked a lot about regulatory issues that are governed in the healthcare sector, federal and state laws and agencies, anti-kickback statute, HIPAA, Stark law, civil monetary penalties law, CMP law, False Claims Act, and then just the regulatory, all the regulatory agencies that are responsible for overseeing the healthcare industry, like CMS, Centers for Medicare and Medicaid Services, Department of Health and Human Services, the FDA with respect to clinical trials and medical devices, and so many more. And then finally, corporate practice of medicine, patient abandonment. We talked about privacy, medical records laws, licensure, and then all the ethics stuff that we talked about. Remember, the ethics while the analysis is slightly different, because you're not talking about laws or rules, you're talking about ethics principles and ethics theories. But the whole concept and process of critical analysis is exactly the same. Like I told you before, my sophomore year of college, my physics class, the professor said, okay, here's the formula, plug in the numbers, turn the crank, and there's your answer. And it wasn't simple for me. It was very simple for him. I'm still not great with numbers. But that process applies uh, equally in sort of this legal analysis process. You have the formula. It's this IRAC method. It's issue, rule, application of facts, conclusion. That's the process. So then you can fill in the blanks, turn the crank, do your analysis, and come out with your conclusion. Again, it's not about what's right or wrong. It's about what's reasonable. What's reasonable, because sometimes, as we saw with one of our discussion questions, um, you are advocating for your client, and so it's your job to advocate for your client and their position and come up with a reasonable argument to advocate for their cause. It may not necessarily be about getting exactly the right answer. So it's about the process. It's about the critical thinking. It's about that analysis. Analysis is the important part. Anyways, that's all I have. For those of you missing assignments, please get a hold of me. I've been reaching out. Please get a hold of me. Let's work on some sort of arrangement to get this done. And I just want to do whatever I can to help you get through this. I don't think anyone wants to take this class over again, and so let's make it so you don't have to. But reach out to me. There are alternative means of getting you to finish this class, whether or not we go the incomplete route and give you some extra time. Whatever the case may be, let's work on something. I'm willing to work with you. So you can finish this class. So it's been a pleasure. I've enjoyed it thoroughly. I've got a lot of papers to grade. If you have any questions or need anything, feel free to reach out to me. You know how to get a hold of me, but I hope you have a fantastic week, and best of luck to all of you in your future classes and careers. And I wish nothing but the best for each one of you. Thanks a lot. Bye.